The state of affairs that the Parliament has sought to remedy by the 46th Amendment of the Constitution was that prior to the promulgation each state attempted to subject the same transaction to tax on the nexus doctrine under its sales tax laws. Consequently, on the basis of one or the other element of the territorial nexus, the same transaction had to suffer tax in different states with the inevitable hardship to trade and consumers in the same or different states. The framers of the Constitution, being fully aware of the problems, sought to check the same by a somewhat complex constitutional scheme and by imposing restrictions on the state's power with regard to levy tax on the sale or purchase of goods under Art. 286, the High Court in the judgment referred to hereinbefore mentioned these factors. It is in this background that Art. 269 was amended and clause within bracket 3 was added to it. The effect, inter alia, is that the power to levy tax on the sale or purchase of goods is now referable to the legislative power vested in the states by virtue of entry number 54 in List 2 of the 7th Schedule. It may be mentioned that Parliament by the 6th Amendment to the Constitution enacted the Central Sales Tax Act, 1956, with the object to formulate principles for determining when a sale or purchase of goods takes place in the course of interstate trade or commerce or outside a state or in the course of import into or export from India, to provide for the levy, collection and distribution of taxes on sales of goods in the course of interstate trade or commerce and to declare certain goods to be of special importance and specify the restrictions and conditions to which state laws imposing taxes on the sale or purchase of such goods shall be subject. In this connection, the High Court referred to the various propositions as mentioned by the Law Commission in its 61st report rendered in May 1974. It was in the aforesaid historical background that the High Court construed the provisions in question and came to the conclusion that a plain reading of these would leave little manner of doubt that the legislative power to tax consignment transfers of goods from one branch of an institution to another branch thereof outside the state and all matters incidental, ancillary or complementary thereto were then declared to be vested in the Union of India to the total exclusion of the states. Therefore, in its true nature, a mere dispatch of goods outside the state to another branch of the original institution is not and never can be the equivalent of a sale either as a term of art in the existing sales tax legislation and not remotely so in common parlance, and construing Section 9 within bracket 1b of the Act, the High Court was of the view that the real taxing event is the dispatch of the manufactured goods to a place outside the state in any manner otherwise than by way of sale in the course of interstate trade or commerce.